Hello, everyone. This is a changed LinkedIn Live address from the original address for this session for Global Entrepreneurship Week Fort Worth. I was having some technical difficulties with the other address. That's Charles. If you follow me on social media, you've probably seen him in a lot of my videos before. If you know of anyone that's trying to get into the session on the old link, please share this link with them. I did put it in the chat over on that link, so hopefully people will see it. But, I think this is the first time I've ever live streamed to YouTube. So we're just working through technical difficulties this morning, and hopefully all of the Global Entrepreneurship Week Fort Worth crowd will come over here and find us. If not, then this video is being recorded. I'm pretty sure, maybe. And we will be able to share it on the Global Entrepreneurship Week Fort Worth website, or whatever archive feature they're using, I'm sure. So this is the Founders Toolkit Contract Basics session. I do have a whole presentation that we're going to be going through, and all sorts of other fun stuff. I will make the presentation that I'm using today available once the session finishes up if you want it, and I will be sure to put my contact information and where you can find me in the chat. As I go throughout the presentation, you're more than welcome to ask questions, post them in the chat, and I will respond as I check it periodically throughout the presentation. Really, this is going to be pretty informal. I want to just go over some contract basics as the title suggests, but I'm going to wait a few more minutes because the session doesn't technically start until noon. And so I want to wait a couple of minutes and just give everyone a chance to get here. Also, I've never played with YouTube Live. I guess I can. Man, you want to talk about a poor, on my part, poor streaming choice using YouTube. I don't think I can share my screen. If I can share my screen, someone tell me how. So this is just turning into a whole adventure that we're going to go on this lovely Monday afternoon now, I guess. I hope everyone is having a great Monday. If you have attended any other Global Entrepreneurship Week panels throughout this morning, let me know what you've thought of them, what your favorite one so far has been, what you're most excited about throughout the course of Global Entrepreneurship Week, what event you're most excited about, all of that. I'm excited to hear about it. And I'm going to give it 1 or 2 more minutes. I need to drink some more coffee because I was obviously not prepared to deal with this technology this morning. The Global Entrepreneurship Week team has been excellent, as always. They are great. They've been great at putting up with my last-minute shenanigans and helping me try to navigate all of the technology, which, as we can tell, I'm doing an excellent job at. 10 out of 10. So it's about 12, so I'm going to go ahead and get started and just hope that this is, in fact, recording so that if GEW needs it at a later date, that they will be able to access it, or I'll be able to give it to them. I was planning to share a presentation, but it doesn't look like I'm going to be able to do that through YouTube. So I'm just going to talk through the presentation instead, and I will put over in the chat right now, if you want a copy of the presentation that I was going to show, or if you want to connect with me on LinkedIn or something along those lines, Instagram, linkedin.com. I will put all of that information in the chat so that you have it. And like I said, I don't know why that, I may have put a space in somewhere where I wasn't supposed to. Nope, still doing that. Okay. YouTube, great streaming platform. Okay, so this is Contracts basics for founders. I find all the time, having worked in the startup community for quite some time, and I guess I'll introduce myself for those of you that may not be familiar with me that are watching. My name is Jessica Vittorio. I am a corporate attorney, small business attorney based here in Dallas, Texas, and I have been working in the startup, small business, technology space for almost a decade now. So I have been hanging around the DFW startup ecosystem for quite some time and have helped companies of all sorts, all shapes, sizes, industries kind of navigate the entrepreneurial waters, whether that be entity formation, general operations, and kind of day-to-day admin counsel, mergers, acquisitions, fundraising, all sorts of fun stuff I've had the opportunity to help people with. So I am well versed in a lot of the issues that startups and business owners tend to encounter, and I of course love hearing. And at Global Entrepreneurship Week and at Startup Week, we generally see a lot of sessions on what I would consider pretty advanced legal topics, things like fundraising, structuring, financing structuring, M&A or exit structuring, all of that kind of stuff. And how we make money from a business is obviously a big question that's on a lot of business owners' minds, but there are a lot of other more fundamental questions that I think founders need to have kind of a good grasp on, understanding from the legal perspective before you can truly appreciate or understand those more advanced topics. So if you followed me on social media, you probably know that I talk a lot about two areas that I think are especially important. One is governance basics. So how do you set up an entity, run an entity? Why do you even need an entity? That sort of stuff. And then two is contracts basics. And today I really want to take that concept of contracts basics and run it as far back as we can. I want to make sure that that's not the GEW team that's trying to talk to me. No, it's not. Okay, so I want to take that contracts basics understanding and push it kind of all the way back to the beginning of the contracts conversation to really ensure that the founders that are watching have a good idea of what a contract in its most basic form is, because I think that is something that is really wildly misunderstood and underappreciated in almost every business regard. And the second thing I want to talk about is how do you create a valid contract? We can have more advanced conversations about all of those higher level topics that I mentioned earlier, the fundraising and the intellectual property and equity ownership and all of this kind of high level stuff. But if you don't know how to form a valid contract to begin with, then you will never get to an effective understanding or memorialization of those more advanced topics, because you'll probably miss some of the most basic elements of creating even a standard contract. So that's what we're going to go over today. And I like to think of this as kind of contracts 101. Now, before I delve into kind of the substance or actual information of the contracts presentation that I'm going to do today, I always like to say, and I start every presentation, if you've heard me speak before, I'm sure that you've heard this. I am an attorney, but I am not your attorney, unless I am your attorney, but I'm not your attorney. So it's always good to use these presentations and this information for educational or general information purposes, but talk to your own counsel or your own professionals before acting on any of this advice. Like I said, I am open to answering questions, so you should be able to type questions in the chat below or possibly to the side, depending on how you're viewing the live stream, and I will answer those questions as we go along. So don't feel like you need to wait until the end of the stream to ask questions. I'm happy to ask that or answer them as we're going along. And that honestly makes it easier, because there's nothing I hate more in the world than watching a presentation and having a really great question that I really want an answer to, and then totally forgetting it by the time I get to the end of the presentation. So don't feel like you have to wait for that. I'm more than happy to answer them as they're posted in the chat. So something that I want to talk about, and I like to give the statistic, you've probably heard the statistic if you've heard me speak previously, but sometimes I think the basics of contracts or governance or entity formation gets overlooked because we really downplay the importance of our small business owners and our business founders. Small businesses in the US outnumber corporations 1,162 to 1. That is a huge, gap in ratio. There are so many perspectives or aspects of your business that you really have to be an expert on when it comes to being a small business owner or founding a business, no matter what industry or type of business that may be, and trying to navigate all of the legal vocabulary and the intricacies of the law can be a monumentous task. So, when I approach legal and when my clients approach legal, I like to think of it in kind of bite sized chunks. Let's start with the basics and then work our way up, building on those basics to the more advanced topics. And I think that that's especially important when we talk about legal, because something that I see really frequently is people misusing vocabulary. And the misuse of vocabulary seems like it potentially is not that big of a deal, but I've seen it lead to a lot of problems between parties over time. And what I mean by that is if you don't have a good understanding of legal concepts and you're misusing legal vocabulary, you can very easily get into a situation where you're negotiating deals that have terms or components that either are not enforceable or illegal for some reason, or you're committing yourself to terms or conditions that you don't actually intend or desire to commit yourself to. And so I think what I try to do in my basics presentations, especially, is give a basic understanding of the concept that we're talking about from a legal perspective, but also give you kind of a checklist of vocabulary that you can use to have your own conversations with your own attorney or professionals, or use that to do secondary research on your own about other things that may come up. And so that's really what we're going to be doing in this presentation. So the first thing I want to talk about when it comes to contracts, finally, we're talking about contracts, right? I talked about all this other stuff that has, little to nothing to do with contracts. And now we're finally going to start talking about contracts. Why do we need contracts? Oh, sorry, you thought we were going to get into the substance. We still have a few more minutes. Just like if you've seen my governance basics videos, either on LinkedIn or Instagram, I think it's really important to have an understanding of the purpose of the legal instrument that we're using, because keeping in mind that purpose as you are navigating creating your own contracts is going to be essential to creating effective instruments. Really frequently, people think that, or people want to use contracts as a way to force their will against the other side, or maybe sneak terms and conditions into an agreement that is outside of the scope of what the parties agreed to. um, I see it happen on kind of both ends of the spectrum, where parties either want to create contracts that are so minimal and so basic that they're not really effectuating the primary purpose, or very similarly, they want to create a contract that's so complex that the parties can't possibly know what's in it or abide by all of it. And then once again, it's kind of undermining its primary purpose. Contracts have really been around as long as humans have been interacting with each other, whether oral or written, formal or informal. That process of, through some exchange of communication, being able to negotiate and come to an agreement on the terms of any sort of interaction between multiple parties is really why contracts were invented. We need some basis of mutual agreement and understanding to be able to engage with each other in a civilized society. And hopefully, that memorialization of the terms and conditions under which we are engaging with each other helps to prevent disputes, prevent inefficiencies in that relationship, and all sorts of other things. So, the purpose of contracts in its most basic form is really just that: it's a memorialization of what we intended. Now, that memorialization can take a whole bunch of different forms. Like I said previously, some contracts we just need to memorialize the very basic material terms, which we'll talk about here in a second. Some contracts require a lot more terms because the deal is much bigger in scope, it's much more complex, there's a lot of moving pieces, etc. And we'll talk about kind of the varying risks and liabilities that accompany both of those, both the informal and formal approaches to contracts. But our purpose is really memorialization, to make sure that the parties understand what is expected of each party for for that transaction or that engagement to go over smoothly. The purpose is where I start to see, like I mentioned previously, a lot of people misunderstanding. If you are entering into a contract with the intention of hiding something from the other party or sneaking something in or anything along those lines, you're trying to bury terms deep within a contract that the parties didn't discuss or agree to. I generally find that to be counterproductive to the fundamental purpose of a contract. Why? Because sneaking something in implies that it's likely the parties are not going to abide by that term, and that may give one or multiple parties kind of recourse against the parties that are is against the party that is not um, abiding by their obligations under the contract. You want a contract because you want the parties to perform. You want the parties to a contract to do what the contract says they're going to do. So, by its very kind of nature, it's ineffective and inefficient to try and hide terms or provisions in your contract to sneak them past the other party, because litigation and attempting to use the court system or other legal means to enforce your contract is generally extremely time consuming, resource intensive, cost intensive, and no one really wants to be in that position. If you've ever talked to anyone that has litigated failure to abide by a contract or breach of contract, they've probably told you it's not a fun experience. So, going into a contract with the mindset that you're trying to sneak something by the other party, as opposed to clearly stating and memorialize what's expected of every party so that relationship can function effectively and smoothly, is not going to serve you well in the long term. Certainly, every party to a contract has the ability and kind of right to advocate for their own best interests. But as kind of a primary understanding, I always find it best practice to do that above board, to have those conversations from a place of good faith, meaning that you're doing them genuinely and sincerely and not with the intention to, sneak something by another party. So, what is a contract? We understand why we need contracts. We need contracts because the way I remember things and the way you remember things over the course of our engagement with each other may be different. That's why we need contracts, memorializations to avoid disputes and to increase the efficiency of our transaction or engagement with each other. So, what is a contract? In its most basic form, a contract has three primary elements. And there may be lawyers out there. There's some legal study website, I'm sure, that's going to come for me for saying this. But I like to think of contracts with three primary elements: offer, acceptance, and consideration. Now, there are some other concepts that float around in the contract creation world, things like legality or capacity or assent, that certainly influence the validity or enforceability of a contract. But for our purposes, to really break it down to its primary component parts, a contract needs three basic things: offer, acceptance, and consideration. So let's talk about what those are. Offer means we have to have one party that has communicated an offer to another party for some sort of transaction or engagement. Now, there are some component parts to that offer. It has to be, or the party receiving the offer has to regard that offer as intentional. It has to be communicated to the person to who will eventually accept the offer, and it has to contain definite and certain terms, which are generally the material terms of the agreement that we're trying to enter into. That doesn't necessarily mean every term, but it has to at least include the material terms. The easiest example of this is if I am standing in line at a coffee shop and I'm talking to my friend John, and I tell my friend John, "Hey, do you want to buy my house?" That is potentially the basis of an offer, but that's not going to be sufficient for establishing a full offer. Why? Because John can't possibly accept or deny that offer based on the information that I've provided him. Now, if I were to say, "John, would you like to buy my house at 123 Main Street for $200?" John has enough information in that information that I provided him to make a reasonable and informed decision about whether he wants to engage in that transaction potentially. Conversely, if I were to say to John, "Do you want to purchase one of my houses for some amount of money?" Well, once again, John has no idea what he's agreeing to, right? He has no idea what property we're talking about. He has no idea the potential amount of money that we may be talking about. And one would logically assume that those two things are pretty fundamental to being able to establish that we want to engage in a transaction with each other. So that process of offer is extremely important. There has to be some sort of offer that the other party can actually evaluate and make some sort of reasonable or informed decision on. So that's our first element. Our second element is acceptance. The party to whom the offer has been extended needs to communicate that acceptance to the party that offered it. That acceptance needs to mirror the definite and certain terms that were provided, and they need to intend to communicate that acceptance. So a big mistake that I see here that I think gets even sophisticated parties oftentimes into trouble is that mirroring of definite and certain terms. Now let's go back to me standing in line at the coffee shop with John. And I say to John, do you want to purchase my house at 123 Main Street for $2,000? If John says back to me, yes, I would love to purchase that house for $2,000, then we have a valid acceptance. If John says to me, I like your offer and I want to accept your offer, but I will only pay you $1,500. That is not an acceptance. While it may sound like an acceptance because he said, yes, I'd like to accept your offer, he hasn't mirrored back to me those definite and certain terms. And that lack of mirroring is going to cause an acceptance problem. What he's actually done is make a counteroffer. What he's actually done is make a counteroffer. Sorry, I got a phone call. What he's actually done is make a counteroffer. So it is now my responsibility as the party who has received that counteroffer to make a decision about whether I want to accept his counteroffer, mirror those definite certain terms back to him, and therefore officially and formally accept his offer. That lack of consistency in the definite and certain terms is really key to effectuating the first two elements of our contract, offer and acceptance. But let's assume John and I are on the same page. He's going to buy my house at 123 Main for $2,000. The last component of a valid contract, enforceable contract, is consideration. Now, you'll see a lot of definitions of consideration out there, but let me give you the easiest and most, the simplest to remember. I was trying to think of something more eloquent, but the simplest to remember, and that is consideration is just an exchange of value. It does not have to be money. It does not have to be fair market value. It does not have to be, any particular type of value. It just has to be something of value, an exchange of value on both sides. If we only have value presented on one side, that is not consideration. That is a gift. And if we have a gift, that has its own rules, but they are not the contract rules. So we need an exchange of value on both sides. Consideration is another area where I think a lot of people have misunderstandings, mostly in the realm of the role that fair market value or fair value might play in valid consideration being established. Generally speaking, it's not the court's role or job to discern whether a party got a good deal or a bad deal. So let's say that I own an antique shop and I had a customer come in and offer to buy a painting that I was selling. And I told them I would sell them the painting for $20. They accepted the $20 offer to sell the painting. They paid me the $20 and they left. Well, a few weeks later, I'm watching Antiques Roadshow and I come to find out that my painting was actually an original Picasso that was worth $50 million. I'm just totally making these numbers and names up. But it was worth $50 million. And I want to go back and get my painting back because I sold it for $20 and it was worth $50 million. Well, is the court going to say that we didn't have consideration, thereby creating a valid contract in that relationship because the value that was provided for the good that I provided was so far below fair market value as to render it, unfair or unjust or unconscionable? Generally speaking, no, the court's not going to undo that. We had an offer, there was valid acceptance, there was an exchange of value on both sides, and that is generally the only question that the court's going to ask. Another area, if we're going to get kind of small business or technology specific, another area that I see a lot of people fall into traps when it comes to consideration in small business or startup contracts is in work for equity or the exchange of intellectual property for equity. If you are bringing people on your team and they are working for equity, and you have a vesting period that takes, a year, 6 months, whatever period of time to take effect, and you terminate that employee or they leave before they've actually accrued any value under that vesting schedule, so they've been given no equity, I think that you should have some serious conversations with your counsel about the consideration that's been exchanged. In startup world, a lot of times I see a lot of people working for free. And you can sign an intellectual property assignment all day long, but if there's been no exchange of value on both sides, then when push comes to shove, you may run into difficulty enforcing that assignment or, the ownership of whatever work product they may have created. So that's just a common example I see a lot of times in the technology world, but there's certainly a lot more. So, what is a contract? Like I said, our basic elements are offer, acceptance, consideration. Now, another kind of basic contract myth that I think is important to talk about is the belief that to be valid, a contract must be in writing. Generally speaking, that is false. Oral contracts can be valid and binding. Now, I'm going to do the classic lawyer thing and I'm going to put like an asterisk on this. Just because an oral contract can be valid and binding does not mean that it's best practice to go around relying on oral contracts. Additionally, there are some forms of contract known as our statute of frauds categories of contracts that have to be in writing to be valid. So let's start by backing up and saying, can we have a valid, enforceable oral contract? Yes, you can enter into valid and enforceable oral contracts. So it is really important to be careful about the things that you're saying to people that you're engaging with. A very, very common example of this is if you had conversations early on with other founders or employees or volunteers in some instance with your organization. I see a lot of founders that maybe have what they view to be informal conversations about, oh, if the company takes off, I'll give you X or Y or Z, or, if you do this for a little while, my long-term plan is that I'm going to make you CEO and give you all this stuff. Those oral agreements can be valid. Now, there are limitations to that, and certainly being able to prove the enforceability or the actual terms of that agreement may be difficult depending on how far out from that original conversation we are. But you don't want to do anything that may create the appearance or the belief that you've entered into an oral obligation with someone. So, for that reason, always being very mindful about the conversations that you're having with other individuals that you're engaging with in a business perspective is extremely important. Yes, you can enter into valid and enforceable oral contracts. However, I would not recommend it. The reason that it's generally not a recommendable, I think that's a word, course of action is because humans are fallible. We're fallible in our memory. The way that we perceive things or remember things over time is going to be different, or it's going to change, evolve, etc. And ultimately, the primary purpose, if we think back to a couple minutes ago in our conversation, the primary purpose of a contract is to make our relationship and engagement with each other as efficient and as dispute-free as possible. If we have a dispute based on an oral contract, the only way for us to really solve that dispute is either to privately come to some sort of agreement as to what the actual terms were and who violated or did not violate them, and then reach some sort of agreement amongst ourselves privately, or to try to go to court and enforce the terms that we believed to be a part of the oral contract that we were operating under. In those situations, you're going to be heavily reliant partially on the actions of the party until that point, or maybe secondary communications like email or text messages or social media messages that the parties have engaged in, but also testimony from each party. And there are lots of situations, and we see it very frequently in the courtroom, where two parties may remember things very differently because anytime you and I use words, we are using an imperfect form of communication. There's a background and a history and a context, and there's a list of assumptions that I bring to every conversation that I have with every word that I use. And your assumptions and context and history and understanding with every word you use are going to be different than mine, just because we're different people, we've had different experiences, upbringings, etc. So we can be using the exact same words, and we can each be interpreting those words to mean very different things. That's why oral contracts are dangerous, honestly, because just because it sounds like we've agreed to something orally, that doesn't actually mean that we've reached any sort of mutual agreement or understanding because of kind of the flaw of that language. That's also why in a well-drafted contract, you'll oftentimes see a brief section of definitions defining words that a lot of lay people will often say, oh, who doesn't know the meaning of that word? Why do we need to have this long definition section with all these words defined? That's exactly why we need to have that section of definitions, because just because we're using what you assume to be a common word does not mean that we're using that word in the same way. So when we have a mutual definition of a particular word that we've agreed upon, then we both can know that we're using it in the appropriate context and we've actually agreed to what we intended to agree to. I don't like to cite case law, especially in presentations like this, but a very famous or popular example of this exact type of miscommunication is called the Peerless case, Peerless. It's very old, and it essentially revolves around two parties' misunderstandings of the word peerless, which was the name of a ship that they were going to be exchanging goods on. They thought that they were talking about the same shipment dates because they were using the name of the same ship, but as it turns out, they were not talking about the same shipment dates because that particular ship was running multiple voyages. So like I said, never rely in an oral contract that just because you're using the same words, you're actually talking about the same thing. And that's why it's generally not advisable to rely on oral contracts and always get something in writing. So that being said, let's go back to a question that I hinted at a few minutes ago, which is what kinds of contracts have to be in writing to be valid? If we know that our general rule is contracts do not generally have to be in writing to be valid, you can have a valid oral agreement. What kinds of contracts have to be in writing to be valid? We find that in a combination of the statute of frauds and the UCC. So, without putting everyone to sleep, thinking that this is a business law course, I'm just going to kind of informally touch on those categories. It's things like promises made in consideration of marriage, sale of goods over $500 if we're in the UCC realm, contracts or promises related to real property, contracts whose terms prevent possible performance within 1 year, guarantor contracts, and certain types of estate and probate contracts. I believe that's all of them. I may be missing one category since I'm doing it off the top of my head. But if you're wondering or want more information on that, you can start your research by using the phrase statute of frauds. The statute of frauds will tell you what categories of contracts need to be in writing to be valid. And it will also tell you if you're in a statute of frauds type of category, what needs to be included in those contracts for those written contracts to be valid under the statute of frauds or the UCC, depending on what territory you're in. So that is kind of an overview of oral versus written contracts. When do we need to have one versus the other? So let's talk for a second about what should be included in your contracts. Now, obviously, the answer to this question is going to vary a lot by the type of contract that you're entering into, what the purpose of that contract is, what industry you're in. An LOI in one industry and an LOI in another industry can look totally different. And I'll back up for a second and talk about a little bit of vocabulary. An LOI is a letter of intent. An MOU is a memo or memorandum of understanding. They're both kind of pre-transaction documents that memorialize an understanding of the parties that intend to engage in a transaction going forward. Sometimes LOIs and MOUs are binding. More often than not, they are not binding. And they're really just there to kind of narrow in and provide kind of a roadmap of scope for the transaction that the parties are going to be continuing to negotiate before final deal documents are completed. That's not every time. Sometimes, parties may only have an LOI or an MOU. But when we're generally using those terms, that's what we're talking about. There should at some point, more likely than not, be a secondary set of documents to kind of pick up the gaps of whatever that LOI or MOU didn't specify. But what should be included in your general contracts? The material terms. I already talked about material terms when I was talking about the primary elements of a contract: offer, acceptance, and consideration. The material terms are the terms without which you cannot go forward with the contract. So if you were to look at a standard written contract, you will see a couple sections of material terms, and then you'll see a lot of sections of kind of legalese or administrative or logistics terms. Those are kind of the supplementary terms needed to make the relationship between the parties as effective and efficient and clear as possible, but they're not necessarily material to the actual fundamental transaction itself. So material terms can be things like identifying the property that's the subject matter of the agreement or the actions that are the subject matter of the agreement. They can be purchase price or whatever value is being exchanged on both sides. They can be timelines, restrictions on the parties to some extent, any really direct expectation of the party that may have directly influenced one party or the other to engage in the transaction. Those are going to be your material terms. I would also generally advise incorporating any sort of representations and warranties that have been made by either party that have influenced one party or the other to engage in the transaction. So, for example, if you were doing a sale of intellectual property of some sort, or let's make it even more simple. Let's say that you were doing a sale of some sort of personal property, like a piece of jewelry, and the seller had represented and warranted to you that that jewelry was diamond and it was produced in a conflict-free manner and it was fully owned by the person that was selling it. Those are the types of representations and warranties that you would want to include in your contract, because obviously those expectations that the seller has put forth are things that you as the buyer are relying on to engage in that transaction. Your purchase price may have been influenced by those representations and warranties. Your timeline or your due diligence may have been influenced by those representations and warranties. All sorts of things could be influenced by those. So you want to make sure that you include those. A good rule of thumb is generally if the parties have said or had communications regarding information that is important to you as a party that's entering into that contract, and you would or would not have entered into that transaction had they given you different information, that is probably something that will be good to put in a representation and warranties section. So all of those kind of contextual pieces of information that have been provided are going to be good things to include in representations and warranties. I would also make sure to think forward about what will happen in the event of termination of the relationship or in the event of dispute of the relationship. Now, no one likes to go into a potential business deal thinking about termination or dispute. But it's really, really important that we think of these things up front, because if we don't think of these things up front, then in the event that we do have to terminate an agreement or we get into a dispute of some sort, it's essentially as useless as us not actually having a contract. So we want to preemptively think through how we want those sorts of disputes handled. Think about things like, do you want to require mediation? Do you want to have to arbitrate? I could probably do a whole second session on instances where it is good and bad to include an arbitration provision. Every practitioner would probably give you a different answer on that based on their own perspective and experience. I tend to find arbitration provisions are overutilized in a lot of situations. I think they're utilized in a lot of contracts where they're not necessarily going to provide a lot of direct value and may actually drag disputes out in the long run, as opposed to providing some sort of more definite end to that dispute. But like I said, I could talk about that for a whole other 2 hours probably, and we could have a whole other session on that. But those are the types of things that you want to think about in terms of what happens in the event of dispute between the parties. Additionally, you want to think about things like, who has the right to terminate a contract? Is it one party or both parties? What sort of notice has to be given? In the event that you are going to allow one party or both parties to terminate, is there going to be any sort of damage that's going to be incurred by the other side because of that termination? And are you going to allow for any sort of payment or fees related to the recoupment of those damages? All of those things are the sorts of questions that you want to think about ahead of time. And while they feel maybe a little bit morbid, if you will, in the transactional sense, to think about those at the beginning of a really promising relationship, I can guarantee that that in the event that you run into some sort of dispute, which if you're in long-term business relationships, there will be a dispute at some point. That is an if, not a, or a when, not an if question. It's just kind of the reality of doing business. And disputes can tend to end in a more amicable way. They can end in a way that may be able to preserve the relationship for future work if the parties are able to point to kind of a neutral document and say, okay, this is how we're going to handle this dispute because here's what our written agreement between ourselves says. It allows both parties kind of step out of the emotional nature that disputes can oftentimes take and find effective ways to problem solve and either work around or terminate that relationship so that the parties can kind of move on. What are some of the most common types of contracts that business owners encounter? Client contracts are certainly a big one, whether that's an invoice, an estimate, terms and conditions or privacy policies are a form of contract. But any contracts that your end user or customer may be touching, those are going to be your client contracts. Those are very, very common in whatever industry you're in. You're probably going to see a lot of employee or contractor contracts. So if you are working with people, it's going to be very important that you have some sort of written agreement with them, not only for pay purposes, but also for ensuring that any work product or intellectual property that may have been exchanged between the parties goes to the rightful owner per the party's understanding of that. I would say in the grand scheme of things that people don't document properly, intellectual property is probably one of the highest up there. It's something people, I think, don't always think about when they should be thinking about who's going to own intellectual property. It's something that they may have had a verbal understanding for, but is one of those things that does have to be in writing to be validly assigned or transferred. So intellectual property, especially in the context of employee or contractor contracts, I think is extremely important. You're also going to see vendor contracts. So when you sign up to host your website on Wix or on GoDaddy or Shopify, Etsy, Amazon, whatever it is you're using, when you create social media accounts with Instagram or Facebook or whoever, all of those are ultimately vendor contracts to some regard because they are providing you goods or services that you are going to be using for your business. And in doing so, you are agreeing to a set of terms and conditions when utilizing those goods and services. So always being aware of those contracts, I think, are extremely important, especially when it comes to things like payment portals. This is a little bit of a tangent, but I think it's important to note your payment portal contracts are extremely important. I very frequently see companies sign up or incorporate certain payment portals into their website functionality that do not actually allow for those companies to utilize those payment portals. So, for example, I'm not going to name any specific portal, but all of the major portals will have a list of industries that they will and will not work with. And they're not always as explicit as saying these are the ones we work with and these are the ones we don't, but most of them pretty explicitly define at a minimum the industries that they will not work in and the types of activity that they will not engage in payment processing for. And those you want to be especially mindful of, because the last thing you want is to incorporate a payment portal into your website and then come to find out, 6 months in, that you get flagged on your payment processor because you're trying to sell alcohol directly to individuals without checking ID, and that is a violation of your payment portal's terms and conditions. That is very common. There are certain types of industries that encounter this issue a lot, especially if you're dealing in alcohol, tobacco, firearms, cannabis, gambling or betting. All of those areas, something sex related, all of those areas are going to have to be very, very mindful of the terms and conditions in their payment processors and have someone take a secondary look at those contracts, especially to make sure that they're in compliance. Very similarly, if you have an app, then being mindful about not only your own terms and conditions, but the terms and conditions that may be associated with your participation in an app store or app platform for whatever operating system that you may be putting that app out for. Also going to be extremely important. And then the last common type of contract that you're going to encounter as a business owner is an owner or entity contract. And what I mean by that is all of your internal governance type stuff. So this is your entity formation documents, your bylaws, your operating agreement or company agreement, your partnership agreement, shareholders agreements, member agreements, all of that kind of stuff are the contracts that are inward facing. They're kind of the rules of the game for how you're going to run your business, who has management and authority making abilities, how do we handle internal disputes, who has the final say, how do we get paid from the entity, all of that kind of stuff is going to be addressed in those sorts of contracts. So once again, those are also very, very important. The last thing that I want to talk about in terms of contracts, well, the second to last thing I want to talk about is the logistics of a contract. Signing contracts, keeping records, and amendments primarily. So in terms of signing contracts, it's obviously extremely important that both parties, or however many parties there are to a transaction, have signed the contract. Signing a contract sounds very simple, but you would be amazed at the number of people that do not actually follow through on the signing component of a contract and get or ensure that both parties have actually signed an agreement. Similarly, a question that I get a lot is a contract valid if it hasn't been notarized? Yes, you can have a valid contract without having it notarized. The only purpose of a notary is really to formally make identifications of the signatories for public record or official record purposes. So, for example, if you're going to be filing a deed transfer for some piece of real property, that is a document that is going to be notarized because it's eventually going to be filed with a government entity. And we want to ensure that the parties whose signature appear on that document are the parties that actually purport to have been appearing. A lot of probate related documents often have to be notarized. The purpose of notarization is not to attest to agreement between the parties. It's not to attest to the substance of the contract. The only purpose of a notary is to attest to the identity of the person that's signing it. That's the only purpose. It doesn't do anything besides that. So you certainly can enter into a valid written contract without signing or without the signature of a notary. And in fact, in most instances, you are probably not going to have a contract notarized. There are only some specific types of instances where a contract will need to be notarized for one reason or another. But making sure that you get both parties' signatures on a contract is very important. And then similarly, once you have all of those signatures, making sure that you keep a record of the fully executed version of the contract is also extremely important. Sometimes there may be multiple versions of a contract floating around. So maybe party one signed one copy and party two signed another copy. So we have both of their signatures on the same version of the document. It just doesn't happen to be on the same exact document. That can be fine depending on what's in the contract. But you want to make sure that you have a record that both parties signed the contract at some point. So keeping records of signed contracts, a draft contract or an unsigned contract is not going to do you any good. You need a copy of the signed contract, a fully signed contract. So if you are in a point where you're trying to enforce a contract, the first thing any professional is going to ask is, let me see a copy of the signed contract. If y'all fully negotiate a contract, but then neither of you signed it, that is more likely than not going to be helpful for you. You want to make sure that you have a copy of the signed contract. And then the last thing I want to highlight in terms of logistics is amendments, especially if you're in a contract where the length of that relationship is going to be very long. You may need to incorporate amendments to the parties' obligations to each other or to certain terms of that contract over time. You always want to make sure that you get any amendments to a contract in writing and that they're signed by both parties, or at a minimum, the party against whom enforcement is going to be sought. And the reason for that is, if you have a contract in writing, you're generally going to be limited to the scope of that writing in terms of the obligations of the parties. So even if the other party has sworn to you up and down that they don't mind if you're always late with payment, if your contract says your payment's due on the 2nd and you fail to pay, it's not really going to be evidentiarily or procedurally appropriate for the court to consider a representation they may have made to you outside of the scope of that written contract, that you can bypass the deadlines included in the contract and pay at a later date. So if the parties do come to some sort of mutual understanding of amendments to how the transaction is going to operate or obligations of one party or another, they want to be sure to get that in writing and get it signed so that everyone's on the same page. And the last thing I want to talk about is what happens when a contract is breached. The first thing that you want to do or look to when a contract is breached is look at the termination provisions, look at the obligation provisions in your contract, and look at, get a full picture of what the contract actually allows for you to do in various types of situations, so that you have a full understanding of what your legal options are. This is extremely important because some contracts will require that a notice be given prior to your ability to terminate the contract, or that there's a certain cure window, if you will. Some may require that any potential violations of obligations are notified in writing. Others may require they only be given orally or not at all. So those are the types of things that you want to be aware of once you believe that a contract has been breached, or if you are anticipating that a contract's going to be breached, because you want to make sure that you've done everything you're required to do as the non-breaching party prior to attempting to enforce that contract against the potential breaching party. After that, there are various types of letters or notices that may need to be sent, maybe a dispute letter or a notice required under your contract. Maybe mediation will be required, or maybe arbitration is required, depending on kind of the scope of your contract. And at that point, once you've looked at the contract, you know what's contained in your contract, what's expected of you, you've followed all of those procedures and given any requisite notices or sent any requisite letters, then you can have a conversation with counsel about the best manner of escalating that conflict. So maybe that's filing a lawsuit. Maybe, like I said, you're required to arbitrate. Maybe that's going to mediation. It could be a whole host of things. But certainly seeking counsel once you get to that point, or even before you get to that point, is always a good idea. Okay, so we have a couple of minutes left before the official end of this presentation. I want to give a couple of more another minute or so for anyone to put questions in the chat that they may have. I know that there are people logged in live, so if you have questions, feel free to put them in the chat. I'm monitoring the chat and I'm happy to answer any questions right now. I did also put my email address, my LinkedIn, and my Instagram in the chat. So if you have questions after the fact, you are always welcome to check out those. My LinkedIn and my Instagram, I put a lot of content regarding governance, entity operations, contract basics, particular contract provisions. I just did a series on contract provisions. So all of those may be good secondary educational or informational materials if you're looking for a little more substance on this. The videos are all shorter than 10 minutes, I'm pretty sure. And they address a wide range of topics, honestly, going back a couple of years at this point. So feel free to peruse all of those and look for hopefully some helpful information, or send me a message. If you do send me a message and you have a particular question about this presentation, or you want a copy of the presentation, send me a message and just put in the message where you saw this presentation, because I do give a lot of presentations. So if you just email me asking for a presentation, I may not know which one you saw and I won't know which one to send you. So thank you so much to those of you that have joined. I don't see any questions in the live chat, so I am going to assume that there aren't any questions for right now, but if you have questions after the fact, feel free to send me a message. I hope that you're going to check out other panels during Global Entrepreneurship Week Fort Worth. I know that there's a great lineup throughout the course of the week, and I cannot wait for some of the other sessions. So hopefully you'll share this, you'll share other sessions happening at GEW Fort Worth, and join us again next year, as well as for Dallas Startup Week. If you haven't checked that out, that is another great entrepreneurial gathering that happens in the DFW community every year. So hopefully this has been helpful. Thank you everyone for tuning in, and I will see you soon, in person or virtual. Bye, y'all.